Good morning. I do not know whether this had happened in Tamil Nadu and other states, but in Kerala, this had happened when some of the companies uh, used the electricity beyond the limited uh, consumption of electricity, and they were charged for unauthorized use of electricity, and that has been referred to High Court. The High Court held differently. Therefore, it went to Supreme Court. The Supreme Court had decided this issue in a different way. Number one, this is AR 2023, Supreme Court 126. Kerala State Electricity Board versus Thomas Joseph Alice, Thomas M.J. and others. Here they say Electricity Act Section 126.6, 45.3, 50, 181 and Kerala Electricity Supply Code Regulation 153. They say electricity supply excess consumption assessment. Consumer drawing electricity in excess of connected load would amount to unauthorized use of electricity as per 126 class 6 explanation B. Thus, regulation 155 subclass 50, which provides an unauthorized additional load in same premises under the same time shall not be reckoned as unauthorized use of electricity, held invalid being inconsistent with 126. 126 means there should be a tampering. Here there was no tampering. Therefore, they say this double tariff is not valid. Apart from this judgment, they have discussed about two doctrines: doctrine of ultra-virus and the doctrine of delegated legislation. This is most important for the postgraduate law student, senior advocates, those who are aspiring to be judges. See, doctrine of ultra-virus, that is applicable when you challenge the very act. Here they have discussed so far some provisions are concerned. That is important. Doctrine of ultra-virus envisages that a rule-making body must function within the purview of the rule-making authority conferred by it a parent act. As the body making rules or regulation has no inherent powers of its own make rules but derives such power only from the statute, it has to necessarily function within the purview of statute. That was different. So, if they are not, if they are exercising beyond the power conferred on them, then that will be ultra-virus. Then delegated legislation would not travel beyond the purview of this parent act. This is what also same resemblance. Once they have to measure whether the exercised power was delegated, that delegation is absence, then the very act itself, very act of the authority itself is ultra-virus. That way you have to read. Ultra-virus may arise in several ways. There may be simple excess of power over what is conferred by the parent. Delegated list may be inconsistent with the provisions of the parent act. So therefore, this judgment should be read for these two reasons. Whether 126, what is the provisions of 126, kindly go through the judgment. It will be better to read the judgment. Best wishes.